When a child's best interest is at stake in Tennessee, what say does the child have in the matter? In past episodes of Tennessee Court Talk and Appointed Counsel, we have covered different types of law practices that cover many different types of courts offered in Tennessee. But today, we're digging deeper into family courts. When a mom and dad are at odds, or the custody of the child is at stake, what rights does the child have, and how can that child be heard? These types of situations are where a judge, like Juvenile Court Judge Rob Philyaw in Chattanooga, appoints an attorney who specializes in difficult child custody cases, like Chris Stiles, to represent a child as their guardian ad litem. On today's episode, we will do just that, explore the ins and outs of the role of the guardian ad litem in the Tennessee court system, and some of the factors leading to an appointment of a guardian ad litem. I'm your host, Nick Morgan, from the Administrative Office of the Courts. Gentlemen, welcome to Tennessee Court Talk.
Thank you. Good morning. It's good to be here.
First, and either of you can answer this, what is the purpose of having a guardian ad litem?
Well, I'll start, and then Mr. Stiles can fill in. I'm really glad you're doing this, by the way, Nick. This is a good topic that touches a lot of cases, touches a lot of families, and there are some questions, as we were talking beforehand. The name implies something complicated when really guardian ad litem has a major role, but a fairly simple role in that they're representing the best interest of the child. And so that indeed is the answer to your question. That's the purpose of a guardian ad litem, is to be a child's voice, whether it's a 1-day-old or a 17-year-old, not necessarily the child's voice in a teenager saying, "This is what I want, go argue it." But the guardian ad litem, there is another procedure for that. But the guardian ad litem's role is to represent the child's best interest, and that may or may not align with the child's wishes, but is a very important part of the legal process in a whole variety of types of cases that I know we'll talk about in a few minutes.
So yeah, a GAL, as those attorneys that get appointed on these typically call it, because guardian ad litem takes too long. It's different in juvenile court than it is in other courts. I mean, in this specifically, we are here just for the child's best interest. As Judge was mentioning, there are times we get into these cases and what a kid wants, specifically a teenager, might not be what the attorney feels is in their best interest, and there could be another avenue that we have to go down for those. But it's different what a GAL, guardian ad litem, is in juvenile court versus chancery or probate, because those are sometimes more investigative than just being an attorney.
Judge Philyaw, I think as a juvenile court judge, people don't always realize how much is going on into the care and protection of a child from the bench. At what point in a proceeding do you as the judge say, wait a minute, this child needs a lawyer, a GAL?
I think it's important to note that under our law, in every dependency and neglect case, the statute actually requires us to appoint a guardian ad litem to represent the child's best interest. In other cases, like custody cases, and that would also apply to divorce cases, it's more subjective. One side or the other may ask that a guardian ad litem be appointed, or the judge may on his or her own decide that a guardian ad litem needs to be appointed to serve as the child to represent the child's best interest. And so depending on the case and the posture, that may be the guardian ad litem may actually be paid for by the parties, or in the indigent cases, like most of a lot of the dependency and neglect cases are, the state would pay the guardian ad litem. But the guardian ad litem is appointed at the front end of that case and is expected to be, and does. I mean, they're attorneys, they're vetted, they're trained. They're involved in that child's case from start to end. They certainly communicate with all the parties, the parents and the state attorneys and DCS, attend child and family team meetings, attend all the hearings, visit with the child, and Mr. Stiles can talk more about the mechanics as he carries them out, because he's very good at being a guardian ad litem, very good attorney, very good at what he does. But, to answer your question, those, depending on the type of cases, the guardian ad litem may be appointed at the very beginning and stay on the case all the way through, or maybe at some point, if it's a custody case, somewhere during the proceedings or, during the case, there's a realization that the child needs representation through a guardian ad litem.
I just assumed it was always paid for by the state. There is cases where the parties would pay for the guardian ad litem?
Absolutely. Yeah. If they're capable, and, usually, so, as a rule of thumb, for example, if it's a custody case and they've hired attorneys to represent them, they can split the cost, or the court can determine who's going to pay for the guardian ad litem. Most of the time it would be, equally between the parties. But in those cases, particularly, more times than not, the state doesn't pay for them, but the parties do. In the dependency neglect cases, it's just the opposite. The state ends up paying for most of those.
Chris, once a judge decides that a child needs a GAL, what does that process look like for you? Does it start with a phone call?
So I'll give you the best attorney answer I can give on any of these types of questions. It depends. Typically, you want to get the pleadings and kind of see how we got here, what's in front of the court, and then go from there. You want to know how old your client is, because a 1-day-old can't say a whole lot. A 14-year-old can say too much many times. But that really depends. And then you've got to find out, as Judge was kind of alluding to, if DCS is involved in the case, it's a different process sometimes than if it's private party. And that's where we get, sometimes you can have a dad that's mad at mom and he files something. That's a gross overgeneralization and simplification of things. But you have one parent that's filing against another parent, and you got to figure out, okay, somebody tell me where this kid is. Some attorneys get kind of antsy if we start trying to speak to their client, mom or dad, before we've talked to the attorney to kind of get the feel of what their side is. But at some point in time, yes, there needs to be a meeting with the kiddo or children, kind of figure out what's going on. Even if it is a DCS case, one of the things that we realize, some of these kiddos can be pulled, and Judge can speak to this, some of them can be pulled out of some pretty bad situations. But the older the kid is, the more that's normal for them. So, it's still, you can have a child that's been pulled out of a very bad situation. All of us would be like, no human being should have to live in that. The kid's coming in going, whatever you do, tell the judge, I want to go home. It really depends on the condition, who filed the petition. If DCS filed, then we pretty much know the kid's, normally that case, that means the child's in foster care. So we've got to figure out where the kid's placed. How can I speak with the kid? When's the next CFTM, child and family team meeting? When's the permanency meeting? When are all these different things occurring, so that we can kind of get up to speed as fast as possible? If it's private party filing those things, then we got to figure out, did the court grant a temporary order giving custody to someone, or is the kid still with the parents? And then we're going to have a hearing and trying to figure out, where we're going on here. So it really does depend on where the kid is, what's filed, and why we're here.
If it's multiple siblings, do you represent the siblings or just one of the children?
You can have one child that's subjected to dependency and neglect or abuse, and the other child may not be. That happens from time to time. When you have a situation where it really, when kids start getting older, say over the age of, when they start getting into double digits, especially in teenage years, you can have one that's adamant this is what they want to do, and another one that's adamant that it's not. I've always found, if I can walk into court and tell the court that my children, that my client's wishes don't align, I ask the court, is this one that I have no problem walking in and telling the court what they want. Advocating sometimes for what they want puts us in a different situation. So if you've got one child that mom and dad is great and they want to be at home, and another child, mom and dad, you're saying mom and dad is horrible and want to be far away, sometimes it's in the best interest of everyone involved to get two different people to represent that. But if it's just a general situation where everybody's interests align, then no, you don't necessarily have to have a different person. So, if it's all the same situation, especially when you're dealing with younger children, a lot of times we'll represent the same, 3, 4, 5 kids, whatever it may be, too, because it's the interests kind of align and how we got here.
Most of the time, it's a whole sibling group, right?
It is. The majority of the time. It's not very often that we have to separate that out.
What kind of conversation is the guardian ad litem allowed to have with the child? And can the parent be in the room? Does the parent have to be in the room since they're a minor? Are there rules around that? I'm sure there are.
Well, let me take that just real quickly. When we appoint a guardian ad litem, there is an order, not just appointing, but there's a pretty detailed order outlining what the guardian ad litem can and can't do. But that order gives the guardian ad litem access to medical records, to school records, and to the child. So the parent does not have to be, and in fact, the parent would not be present in some of those discussions. The parent may be present in some because the guardian ad litem may want to observe how the parent and child, interact with each other. Being a guardian ad litem takes special skill. It's not, it's about being a lawyer. It's about the legal technicalities. It's about being an advocate for a child's best interest, but also there's huge social aspects involved in what we ask guardian ad litems to do.
So, Chris, a follow-up to that, how is being a GAL different than representing an adult?
Oh, wow. I think being a parent's attorney on cases makes me a better guardian because I'm understanding all avenues or the different perspectives on cases. But it is a lot different. I mean, you've got, at the end of the day, you realize you're still dealing with representing a child, and trying to do what you can to protecting the innocence of that child as much as you possibly can. And sometimes, sadly, that's gone way before we get involved in these cases, but still doing what we can to treat each case and the kids in their best interest in that given case. It's different because, representing a parent, you're trying to protect constitutional rights and you're arguing over things that, their right to parent, and this may not be this what they're doing may not be the safest, but they have a right to do certain things. And when you're representing a child, you're doing what you can to try to protect that kiddo as much as you possibly can, or those children as much as you possibly can.
Chris, from your position as a guardian ad litem, what recommendations are you allowed to make to the court?
Knowing the magistrates or the judge that you're in front of, for those of us that do this in multiple counties and do it in different spots, I mean, there's different expectations. And the types of cases that you're on can determine that too. I mean, if you're doing a termination of parental rights / adoption case versus a standard DCS case, I view that role, and you could probably interview those of us that do a lot of the GAL work, and every one of us will kind of have a little bit of a different take on this. But I view that role, especially if DCS is involved, the Department of Children's Services are involved in the case, to kind of holding everybody's feet to the fire to make sure we're doing right by a kid. Being there, you're not there just to rubber stamp what DCS is asking for. You're not there just to, agree with one of the parents. You're there for what, in my level of expertise, is for that child's best interest. Sometimes that's what DCS is asking for, and you can sign off on it. Sometimes it's not, and the parents are pushing back on certain things, and we have to go that way too. But as far as the recommendations we can make to the court, again, it depends on the judge or the magistrate you're in front of. Some will just stop and ask at the end of proof, what do you think? And you're allowed to say it. Others not quite so pointed with how they're asking for it. We just kind of give a closing statement like we would if we were representing anybody else in the case. But I think from those the ones that I'm in front of on a regular basis, the weight of a GAL's opinion weighs heavily in a case. If we've met with the child and we've done our work and our due diligence, what we should do on the front end of those cases, I think it weighs a lot.
So, Judge Philyaw, as Chris was talking about the recommendations, how do those recommendations from a guardian ad litem factor into your decisions on the bench?
They may make recommendations as such, but most of the time they're just going to be more arguing or presenting the case as they think it should be presented. They can examine witnesses. They can subpoena witnesses. They cross-examine witnesses. They make arguments. And so they're literally not just there to make some recommendation at the end of a case. They're an active participant in the whole litigation. And so they have multiple opportunities to make a point or to represent the child's best interest. And then make those arguments in closing arguments, including their recommendation or what they're asking the court to do with that case. And as Mr. Stiles said, they're certainly not there to rubber stamp what DCS is arguing, although many times they're aligned. They're there to represent the child's best interest, and that may be, judge, send this child back home and let this family be reunited. That may be the guardian ad litem's argument, and I've, of course, had that argument.
We've addressed this, but I want to be more specific. Where does the job of the guardian ad litem end? I know it would end with whenever the case is finalized, but for example, if a case gets appealed to the appellate court, can the guardian ad litem change from trial to appellate? And Chris, this may be a question for you. I'm not sure. I know that can take years to get to appellate court sometimes.
Obviously when a child ages out, and we do have some cases that is how they, as far as the guardian ad litem's representation ends, because once they're emancipated, reach the age of majority, when they turn 18, they're not entitled. But yeah, so again, different counties and jurisdictions do this a little bit different. I think the statute's pretty clear that once we're appointed on a case, regardless of our capacity, guardian ad litem, parent's attorney, or whatever, it's thought that through that petition, we're on the case until it reaches its finality. So, if it's dismissed, then that resolves it. If, in these DCS cases, if the parents work their plan and get custody returned, then that pretty much resolves it. Where it gets confusing is if a termination is filed on these cases, that's actually a new petition. Now, I know most of the time, I think most of the courts that I'm familiar with, if you're a GAL and you're familiar with the case, they want to ask, or you would typically get a call asking, would you be willing to take this? And then you're on it for the termination part of it, because sometimes, and Judge, you can speak to this as well, sometimes if the case originates in a magistrate in juvenile court, the termination is filed and judge hears it. Sometimes that same DCS can file that case in circuit court as well. And so the circuit court judges a lot of times don't know a lot of us that do a lot of just juvenile work. And again, every county kind of handles this a little bit different. I know some counties where the general sessions, the judge with juvenile jurisdiction doesn't hear TPRs because they've got so many other things going on. But in those cases where that happens, if there's a TPR filed and we get appointed on it, we're on the TPR until it's concluded. It's not concluded until the appeals process runs. If there is an appeal filed, we still should be on it. Now, I guess we could file a motion or something to ask to be relieved, but I don't think that's what's really contemplated. We're the ones that know the case, and we should be able to do it. But yeah, we stay on it until it's over. So if it goes to the Court of Appeals, then it goes up there. And the orders say we're on it till it's done.
My appointment orders say to the Court of Appeals as one of the stages. I'll actually appoint for several different stages of the case. Okay. The attorney can get paid at several different stages. But you're talking about the appellate courts. The guardian ad litem's role is very important there too. There's an often cited case from right here in Hamilton County. It was my case. It was a termination. It was a termination case. It was my case at one point, and it went to another court. The Tennessee Supreme Court ended up hearing the case, and the guardian ad litem had a vital role in that argument and in crafting that decision. So it was just a good example of a guardian ad litem literally making it all the way to the Supreme Court on a DNN matter.
Judge Philyaw, Chris, thank you both so much for taking time to speak with us on a delicate but important subject. It's been a pleasure to sit down with you today.
Thank you, Nick.